Next up, we've got Garbhan Shanks, who is going to talk about case law update. He is a managing associate in our litigation team who specialises in insurance, reinsurance, arbitration and commercial litigation.
I'd like to first start off talking about the Basma Al Suleiman against Credit Suisse and Plurimi Capital judgment. Justice Cook handed down his judgment in March this year. We acted for Plurimi Capital. This case concerned a claim for alleged mis-selling of structured products with the use of leverage, resulting in losses to the claimant of over $30 million US, essentially because she failed to meet a margin call in October 2008 when the financial markets were in meltdown, causing her account to be liquidated. What we faced with at the beginning of this trial, or the case I should say, is a high net worth Middle Eastern woman who contended that she was an unsophisticated, mere housewife that didn't understand anything about the financial world. She said that all she ever wanted was low risk investments, and she certainly did not want any risk to her capital. She contended that the margin call of $10 million US, which Credit Suisse Geneva asked her to pay when the markets were going downwards very quickly, she said that she couldn't afford to pay that, and as a consequence all of these notes were basically unsuitable for her. This pleaded case changed dramatically during the course of the proceedings, brought about mainly by late disclosure forced on her, which essentially contradicted the whole of her original allegations. So the main battleground for us was a dogged determination to pursue her for specific disclosure and information requests during the whole of this litigation, which Justice Cook described as a torturous process which continued right up until the date of trial. The defendants were not satisfied that even then full disclosure had been given. Neither am I. The judge was just not impressed by this woman. He was not impressed at all by the approach she had adopted to disclosure. So, for example, the claimant's allegations as to her wealth or her risk profile were completely abandoned during the course of this trial once we had actually got further information out of her showing that in fact she was basically sophisticated. She actually had all the various other investment activities going on with other banks that she hadn't disclosed originally. These banks were described her as an aggressive investor. She had actually invested in structured products with these banks. She had used leverage. So a lot of these rigid allegations she was forced to abandon. They just collapsed. They were withdrawn before we actually got to the court. For example, in a statement of case, she started off by saying that she was only worth $15 million US. Initially we thought, God, this actually looks quite bad. She had a portfolio of 80 million, she was only worth 15 million. We were slightly concerned, but by pushing through the process of requests for further information, they were forced to amend their case. And essentially they pleaded that she was actually worth 85 million. The judge found clearly what she had been stated was plainly not true, and found that this is a clear example of dishonesty on her part, where correction was forced on her as disclosure documents were ordered against her. So in fact, when we actually got to trial, we discovered that she was worth about 150 million. So we'd gone from the starting point of 50 million, and she was actually worth tenfold. So her credibility was shot as a result of these concessions and these revelations. So when we actually turned up to court, her case was pretty much on its knees already. She had to abandon a lot of the original allegations she made because they were false and they were dishonest. And the only thing she was left at, and her case changed midway through trial, was an allegation that essentially our advisor had failed to explain the risk of not meeting a margin call. And they stated that this failure meant that they'd failed in their duty to provide reasonable steps to provide suitable investment advice to her. Now, throughout the course of the relationship with Credit Suisse and then our client Plurimi, Mrs. Al Suleiman had been provided with various risk warnings, and indeed she'd been sent emails communicating to her about the risk of these products, etc. Her case was that she just didn't read them. She didn't read them, didn't understand them. Had she read them, she wouldn't have even understood what a margin call is or a pledge. And essentially her whole case was that she was relying on her advisor to explain to her orally what risks she needed to know. The court found that her evidence regarding the understanding of leverage and margin calls was completely inaccurate and unreliable, and in fact dishonest. They found that she was an intelligent woman, and she clearly had no difficulty grasping, the concepts of, financial products, and it was inconceivable that she hadn't discussed and understood the risks of these products. So therefore, the court found that there was no breach of statutory duty nor any other duty in terms of our clients that adequately explain the risks of these products to her. So the points to take away from this judgment is firstly that the requirement to take reasonable steps, the duty to take reasonable steps and to explain these risks can be satisfied by both written and oral representations. And secondly, an advisor is entitled, in the absence of a clear direction to the contrary, to assume that a literate and educated investor will read risk warnings that are expressed in straightforward terms. She was contending she just didn't read them and wouldn't have understood them. That is not correct. If the investor is intelligent and educated, one can rely on that fact that she will read these standard risk warnings. Furthermore, the court found that the claimant was able to meet the margin call, she simply chose not to. The judge described this as an irrational decision, and that irrespective of any failure to explain the risks of margin calls, that decision would have broken the chain of causation in any event. One quick point to note in the context of these allegations of negligence against our clients, negligent advice, was that the judge also found that the extreme events of October 2008 were essentially unforeseeable. Our client has sold these products, these notes to Mrs. Al-Silman over a 5-year period, 22 notes in total. The last was sold to her in May 2008, and at that point the judge found that the financial crash was just not a foreseeable event at that point in time. So that was just an additional point that he made. Concluding comments on the Al-Silman case, I think it's probably little doubt that the outcome of the case was significantly influenced by the fact that the judge decided she was dishonest, and that was brought about by the dogged persistence in going after round after round of specific disclosure applications and further requests for information. She simply did not want to give us the information, but eventually we forced her to expose her lies, and her case collapsed. We won outright, and as a result of the dishonesty findings, we got all our indemnity costs against her, which is obviously a great result for the client. Secondly, the VTB Capital and Nutritech case by the Supreme Court. I just want to focus on the issues and discussions on the piercing of the corporate veil in that matter. There were various other things also decided. Brief background: VTB Capital was a bank that lent $225 million to a Russian company called RAP. They lent that money for the purposes of buying dairy farms in Russia from Nutritech. RAP defaulted on the loan. The bank brought a claim alleging that they had been induced into the loan agreement by fraudulent misrepresentations. One of the key alleged misrepresentations was that Nutritech and RAP were not under common ownership. They had nothing to do with one another as two separate companies. In fact, it turned out that a Russian businessman called Mr. Malofeev essentially owned both companies. So the court went on in that case to decide whether it was permitted to pierce the corporate veil. It was essentially argued by VTB that Malofeev controlled RAP and Nutritech, and that the corporate veil should be lifted so as to expose Malofeev as essentially the puppeteer behind the fraud of entering into these contracts in the first place. The first thing of note is that Lord Neuberger gave the lead judgment on piercing the corporate veil, and he confirmed the test which has been laid out by Justice Munby in the Hashem against Shaif case, as is on the screen. I won't repeat it. The only thing to bear in mind, or the thing to retain of actually critical importance in all of this, is that the concealment must be happening, or the company must be put together, or the assets must be put into the company and for the purposes of the wrongdoing at the time of the relevant transaction. So therefore it's quite critical that when the company is set up, that it's set up for that wrongdoing. We'll come back to that in a sec. One further thing to just bear in mind in all of this debate over piercing the corporate veil is the case of Graminsky. There was a judgment by Justice Burton in 2011. Now there he went on to possibly extend the concept by arguing that, or certainly stating there's a good arguable case that where the ultimate beneficiary of a company sets up that company for the purpose of fraud on the claimant, i.e. preventing that claimant getting access to the assets, etc. They said there's no good reason why a puppeteer should not be a party to the puppet company's contract. In other words, the individual is committing the fraud and is pulling the strings behind the scenes, that they should be able to pierce the corporate veil and go after that individual. That's essentially what VTB relied on in this case. On the facts, the Supreme Court found that VTB's argument could not succeed because it involved not just piercing the corporate veil, but going on to find that Malafide was liable as a co-contracting party to the loan agreement, even though, of course, the two companies that entered into the loan agreement never intended him to be a party to that agreement. So the thing to retain from this decision is that the Supreme Court is refused to extend the existing principles of contract law by piercing the corporate veil in this matter, as argued by VTB that should occur. And what it does, it pushes us back to a more orthodox approach and gives us more certainty under English law in terms of English contract law and fundamental principles such as privity of contract and the separate legal personality of the corporate entity that entered into that contract. Finally, one thing I just wanted to quickly cover off is the press against Petrodel case. Many may have seen it in the press last week. This Mrs. Press was essentially divorced her husband, and she had a £17.5 million divorce settlement which she was trying to enforce against him, and the question was whether she could get hold of the properties that he had put into offshore companies, and the Supreme Court found that these offshore companies were to transfer the properties to Mrs. Press, who was entitled to them under the divorce settlement. And the justification for this is the Supreme Court found that the husband and not the companies had originally put up the money to buy these properties. So they were able to apply the law of trust to say that these properties were held on trust by the company for the benefit of the husband, and therefore he could and should transfer them to his ex-wife. It's important to note that the Supreme Court was at pains to emphasise that they were not piercing the corporate veil in this case. It was one of the grounds for the appeal, but it was not a ground that succeeded on the facts of the case, and they wanted to emphasise that it can only be used in extremely limited circumstances. Supreme Court Justice Sumption gave quite a good summary of how one should approach piercing the corporate veil, and he described it as the evasion principle. And I'll read out, he said, there is a limited principle of English law which applies when a person is under an existing legal obligation, which he deliberately evades or whose enforcement he deliberately frustrates by interposing a company under his control. So the court may then pierce the corporate veil for the purpose, and only for the purpose, of depriving the company or its controller of the advantage that they would have otherwise have obtained by the company's separate legal personality. So basically what that means is that in this case, they weren't able to pierce the corporate veil because when Mr. Press set up these offshore companies, it was for the purposes of tax avoidance. It was nothing to do with the ultimate unravelling of their marriage and the divorce and him trying to hide the properties against his wife who couldn't access them. So for those purposes, piercing the corporate veil was not a relevant remedy in that case. So the message is the evasion principle is what now should be looked at when you're looking at piercing the corporate veil, and also the court was at pains. It's very, very limited circumstances where one can do so, and you basically have to look at all other legal remedies available beforehand. Thank you very much.